Hello and welcome. I'm Catherine Mitchell, the Director of Mitchell Law, and this is the Mitchell Law Tea Break. It's an occasional series on employment law for HR professionals, and I'm joined by Joanne Sefton, our in-house barrister.
Hello Catherine. So what are we going to talk about today?
Well, moving slightly outside our employment law comfort zone, we're going to be talking about the GDPR. Given that we're very close to the live date of the 25th of May, and given it's so relevant for us and HR professionals across the land, I thought it'd be rude not to.
So, are you afraid of the GDPR?
No, I'm not. I think it's great. But I know that puts me in a minority quite small, and I ought to give a really big health warning here and make it clear I'm not a data protection lawyer.
And whilst we're not data protection lawyers, it would be fair that it's important for us to understand the new regulations for ourselves, but also because our clients and every HR team is going to need a working knowledge of them too.
They do, and I think we ought to be really knowledgeable for ourselves on data protection, and the GDPR is a good way of arming ourselves with useful information about how our personal information is gathered and used with or without our consent.
So, taking the question of consent into the employment world, is it all right data-wise if employers just update their contracts and put a new consent clause in there?
No, afraid not. And that's been one of the many myths about GDPR that have been circulating. And how about we look at what GDPR is really about and how to get started if you've been hiding behind the sofa?
Sounds good.
Okay, well, part of my enthusiasm for GDPR is that it's proving a fantastic prompt for all sorts of organisations to be much more savvy about privacy issues and much more focused about people's rights in relation to their data.
And I suppose that can only be a good thing when we've been hearing so much about Facebook and Cambridge Analytica's harvesting of personal data from Facebook users, that sort of scandal.
I think so, and that's only the latest in a long line of scandalous stories of deliberate misuse of data by organisations we might have thought were law-abiding, and that's even before we add in the hackers and career criminals who are busy testing the security of IT systems across the world to get our bank account details or personal data.
So how does GDPR make all that better?
Well, for a start, I think the first principle is that data must be processed fairly and lawfully, and it requires organisations to focus on privacy and data protection by default and design.
So that means?
Well, essentially, it means you have to have data protection at the heart of all the procedures that you set up and operate. And the way you operate has been designed to minimise the risk of accidental data breaches.
Okay, and what else is different?
Well, going back to the myths around consent, for me, the other key thing for HR to grasp is the concept of the lawful basis for processing.
And is this what we're going to use instead of consent?
Well, it's more that consent is just one of 6 possible ways of justifying the processing of data, and it's probably not the one which we'll often rely on in HR. I think it's going to take a long time to get over the idea that consent is the answer to most data processing, but GDPR makes it clear that consent has to be freely and genuinely given.
And I've read the commentary points into the imbalance of power in the employment relationship, and that means consent of employees where it's obtained through a clause in their contract to gather data, to store data. It may not be freely given if their job offer depends on it.
I think it makes sense if you think about it. So the GDPR gives us 5 other lawful basis options for gathering and processing employee data. The primary ones for HR are going to be performance of a contract and legal obligation.
So can you talk me through those?
Okay, well, if I offer you a job and you accept, I ask you for your bank account name and address, and I'm entitled to ask you for those and process them because it's in performance of a contract between us.
Okay, so far so good.
And then we go on to the next lawful basis, which is legal obligation. I'll also ask you for your NI number, your P45 from your previous employer, because HMRC would like me to collect tax and NI, or they'll come and pay me a visit, and that's about a legal obligation.
All right, so we've got consent, performance of a contract, legal obligation. That's 3. What about the other 3?
Well, there's vital interest, and this one isn't going to figure on the radar of many HR folk. It's really only relevant to life and death situations. So you're talking about possibly in an A&E department where you're disclosing people's personal data. Then the next one is all about public task. So you can rely on this one if you need to process personal data in the pursuit of your exercise of official authority. So public functions and powers, and it's more relevant to public authorities, but occasionally utility companies, for example.
So that's 5. What's the last one?
Well, the last one is the lawful basis of legitimate interest, and this is the most flexible one.
So is this the get out of jail free card?
Well, I'm afraid not. Although it's the most flexible one, you can't always assume that it will be the most appropriate, and it's more likely to be the one that you rely on when you're going to use people's data in ways which they would reasonably expect, and where there's a minimal impact on their privacy, or there's some other compelling justification for processing it. So if you're going to rely on this basis, you need to jump through some more hoops. And it's not a get out of jail free card which allows you to process the data if you can't identify another lawful basis. And under this one, you do have to identify precisely what the legitimate interest is. So an example could be the retention of data when you expect legal proceedings to be brought by an ex-employee. And you have to show that it's legitimate and necessary.
So is that it?
No, because you then also have to show that you've balanced that legitimate interest against the person's individual rights and freedoms. So if you're anticipating that employment tribunal claim, you'll have a legitimate basis for holding on to the data, and that's likely to trump their rights and freedoms over the data.
Okay, so we all need to know quite a bit more about data protection than just how to deal with a subject access request. That's been the main area where we've had crossover in the past.
Yeah, it has, but the data subject access request will still exist, although it's now being described as supercharged.
So what does that mean? There's a lot of new jargon to grasp with this GDPR stuff.
There is, and don't even get me started on granular. But I think the reference to supercharged reflects that the data subject, or person as I like to describe them, has much greater rights when it comes to obtaining information about the use of their data. And the supercharged request is just one of those rights. And some things will change, such as the £10 charge goes away, and the request being complied with needs to shrink to 30 days.
So what else do our clients need to tell employees about their rights?
Well, information which data controllers, which will be the employer, need to provide to individuals about the use of data is prescribed, and it needs to be how the data is processed, the legal basis for it, the categories, the recipients, the period of storage, and the rights of those data subjects.
Tell us about the rights, because that bit sounds quite interesting.
Yeah, well, the key ones are rectification of data. So if I hold incorrect data about you, you have the right to require me to correct it, and you have to do that I have to do that within a month. You've got rights to object to processing. Now I can balance those with my legitimate interests. You have the right to restrict processing or request your data to be provided to you in a commonly used format.
Okay, and I was reading about the recent Google case. Is that about the right to be forgotten?
Yeah, that case was about 2 people who wanted Google to remove links to their criminal convictions, which was showing up many years later in searches. There have been a few cases testing this in the courts. But what the GDPR does is enshrine this right to be forgotten as one of the individual rights. It doesn't mean your right to be forgotten if the data controller has a legitimate interest, but it does give the area some more teeth.
It could be handy for people for some of the wrong reasons.
Yeah, it could, and there are limits on the right to be forgotten, and we could discuss some very interesting cases of people in the public eye who've been testing the principle, but maybe another day.
And are there any other new rights that HR teams need to be aware of?
Well, I think there's probably just one, really. There's an interesting one which comes into play in relation to recruitment. And if you use automated aptitude tests, which don't require any human involvement in the decision making, if you use those, there are additional safeguards you need to consider because it's regarded as a higher risk. So it's recommended you carry out a data protection impact assessment.
I see. So if I wanted to find out about the information you hold on me, where do I start?
Well, many organisations are going down the route of producing a single privacy notice which sets out all you need to know in terms of how your data is used and what your rights are.
So it should be relatively straightforward to put all of those in one place.
Yeah, relatively straightforward, but you do need to know what data you hold, where and what you do with it before you can produce a decent one.
Okay, so there's quite a lot to do before the 25th of May. Should we all be panicking?
No, I don't think so. If we're reasonably careful about data already and we're making progress with auditing all of it, getting a data register together and thinking about what's going into it, I think we'll be reasonably okay.
And what if we're not totally all there by the 25th of May?
I would still say don't panic, because the Information Commissioner herself has said that GDPR is a journey and not a destination, and it's asking us to get into a new mindset. And although the big fines and noise about enforcement will provide some focus, most organisations who are sensible aren't going to be getting into trouble.
So any final thoughts before we go back to employment law?
Yeah, don't be afraid of the GDPR and get to know the Information Commissioner's website well. It's full of really good stuff, facts, guidance, myth busting, and it is a straightforward read.
Good tip. Well, thank you for joining us. We hope you've enjoyed our slightly light-hearted look at the GDPR. That was the Mitchell Law Tea Break. Join us again soon.
Thank you.